What started as a routine drug possession hearing is about to turn into a courtroom battle over one critical question: was this simply possession, or was there enough evidence to prove drug trafficking? Prosecutors say the defendant had everything needed to distribute cocaine, while the defense insists police never actually found drugs on him. With both sides presenting completely different versions of the facts, the judge now faces a decision that could dramatically increase the seriousness of the charges. Stay with us, because the ruling may not be what everyone expected.
Discovered he was informed not to flush the toilet, did so anyway, was also informed not to make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can away from the view. There was fervent movements with his hands, and then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which generally right after he washes his hands. Your Honor, so it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond an address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was a possession with the intent to deliver, which would be a delivery of manufactured controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and
The prosecution has now laid out its entire theory. Their argument isn't based on the drugs alone, they're asking the court to look at the complete picture. According to prosecutors, the combination of large amounts of cocaine, crack cocaine, a digital scale, packaging materials, and the defendant's behavior inside the hospital bathroom all point toward intent to distribute rather than personal use. But now comes the defense's opportunity to challenge every one of those assumptions. Will they create enough doubt to prevent the additional trafficking charge from moving forward? Let us know in the comments, which side sounds more convincing so far.
Well, Officer Colarossi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements, but at the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but, that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive possession. There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And
after hearing both sides, everything now comes down to one question: has the prosecution shown enough evidence for probable cause? It's important to remember that this hearing isn't deciding guilt or innocence. Instead, the judge must determine whether enough evidence exists for the case to continue to trial. The defense argues there is no direct proof connecting the defendant to the drugs, while prosecutors believe the surrounding circumstances create a reasonable inference of possession and intent to deliver. The judge's next words will determine whether these serious charges move forward.
For constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal. The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams.
In the end, the judge ruled that prosecutors presented enough evidence to establish probable cause on both charges. That means the defendant will now face trial for possession of cocaine as well as possession with intent to deliver less than 50 grams. The court also acknowledged the defense's legal arguments about constructive possession but concluded those issues are ultimately questions for a jury to decide during trial rather than at this preliminary stage. The final outcome of the case has not yet been determined, but the courtroom battle is far from over. What do you think? Did the judge make the right decision based on the evidence presented, or should the case have been dismissed? Share your opinion in the comments below. And if you enjoy real courtroom breakdowns like this one, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss another dramatic legal case.